Judge rules no appeal in the Delphi case. This is the fastest turnaround I've ever seen. The defense team in Delphi case asked for interlocutory appeal on September 9th. On September 11th, judge slams the gavel and says, no appeal for you. In this particular case, the defense team was asking for an interlocutory appeal. Interlocutory appeal is basically an appeal while the case is ongoing. So there's not a verdict, but this is basically saying, hey, there's a substantial question of law that if we don't get right, it's going to affect everything. Therefore, we want the Court of Appeals to check it out. Interlocutory appeals are unique because in order to do an interlocutory appeal, the trial judge has to sign off on that appeal. And then even if the trial judge signs off, the Court of Appeals can also say yes or no. So there's multiple factors for interlocutory appeal, but it doesn't matter because the trial judge said no appeal for you. So what happens next? Well, it's going to be a lot harder for the criminal defense team for Richard Allen. That's the biggest thing, because you don't just get to say, well, we wanted the evidence in, therefore we're going to appeal it at the end. In order to preserve the right to appeal this evidence of third-party perpetrators, the evidence of geofencing, and also the suppression of these confessions, Richard Allen's defense team is going to have to stand up during the jury trial and object. Objection to the confessions of my client. Objection to the exclusion of evidence. That's going to be a weird one, but ultimately they have to do an offer of proof, and at that point, the judge looks at the jury. Ladies and gentlemen of the jury, we're going to excuse you for a brief moment. Get out of here. Jury walks out, and then the defense team gets to basically tell the judge what they think their evidence is going to be. And there's a whole legal process for this, but every judge kind of does it their own way. So some judges, when I've had to do offers of proof, they wanted the witness on the stand. And we asked questions as if we were going to do the jury trial in front of the jury. The jury wasn't there. And in some cases, the judges have said, hey, thank you. We're still excluding it, but you can get out of here and bring the jury back in. And the jury has no idea what the witness testified during these little mini offer of proof. In other cases, I've done offer of proof with the witnesses there, and the judge has reversed course. Oh, well, you know, I did say they were excluded, but based on what I've heard today in this offer of proof, I'm going to let it in. Obviously, I was happy when this happened, but that's been it's more common that it has not been let in after an offer of proof. Some judges have said, hey, Mark, we don't need witnesses here. Just verbally tell us what the witness would testify to. For the defense team's sake, I'm hoping that the trial judge allows them to do that, because they did all this other evidence in this 3-day hearing where the judge said there wasn't enough evidence for the geofencing, third-party perpetrators, and also the confessions as part of the suppression motion. In any other case, they probably would just email the judge, hey, judge, copy opposing counsel, the prosecutor, how do you want us to go with the offer of proof? They don't really have that relationship with the judge. In prior filings, I've saw the judge made a comment. I don't like doing emails because then I send you emails, they make it into motions, and that's not what makes me happy. So they're going an uphill battle. They're going to have to figure out what the judge wants for these offer of proofs. The end result, though, is these issues, the judge may think they're slam dunk, and that's why she's not giving interlocutory appeal. But ultimately, if Court of Appeals or even Supreme Court says she was wrong, the trial may have to be redone, and that's not going to be fun for any of the people involved. That's not going to be fun for any of the attorneys involved. If these original ones are in there, they're still going to have to get caught back up. If it's new attorneys, they're going to have to read through thousands and thousands of pages of motions and evidence. It's going to be horrible. And also, I've done a number of appeals. Appeals, you're reading evidence, you're trying to categorize evidence, you're trying to keep track of everything. This appeal, right off the bat, if Richard Allen loses in appeals, is going to be just gigantic, because not only do they have to appeal the confessions, the geofencing, and the third-party perpetrators, they're going to have to appeal anything that actually happens during the jury trial. It's going to be a monster appeal. Again, I do not envy what is ahead for the team defending Richard Allen, and I've never seen a faster turnaround for a judge denying interlocutory appeal than in this particular case. So if you have any questions about this case, leave me a comment. I will do my absolute best to respond to each and every comment. Can't promise I will, though, but I'll try. And if you've watched this far, please like and subscribe. Leave me those comments. You guys always make me smile when I read these comments. And most importantly, remember to always plead the fifth.